For pronouncement of judgment, item number 1 to 4.
In the facts and circumstances as discussed above, this court finds that the petitioner has not been able to make out a case to invoke the jurisdiction of this court under Article 226 of the Constitution of India, and the petition, being devoid of merit, is dismissed. Just send it to me.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention hearing item 14, Lordship.
Item
14.
14.
14. Lordship,
Yes.
Lordship, here for respondent 4 and 5. I have a consensus prayer if this matter can be listed after Easter vacation, Lordship.
You give a date. So that means 6th. 6th, 7th, item 14. Item 14 is criminal revision.
It's
Criminal
18.
revision.
This is the case.
DPP 97.
97 of the
That is 18.
Mine is shown as 14, so I beg your pardon.
Yes.
For item
Okay.
18.
Learned Counsel, Mr. B. Sultana.
V. Kozar.
Oh, Koza, yes. Mentioning on behalf of the respondents, please for listing the matter. When?
I'm ready for the time.
After 2 weeks.
Yes. He said, your seniors told me that after vacation, that's what he was saying.
So after vacation will be 6, 7, 8, 9. Any date? April. Second week.
Second week, it's okay.
Lordship.
On 7th April. Stop. The Learned Counsel for the petitioner, Mr. M.T. Longcham, is present and has no objections. List on 7/4. Yes, for hearing.
Much obliged.
May I please, my lord? Lordship, I beg to mention item 6 on behalf of my colleague KV, Lordship. Lordship, he is in bereavement if this...
Item 6 is an insurance matter.
Yes, however, state
Oh,
is also a party, I'm told, Your Lordship.
Okay. Item 6. Yes. Okay.
Lordship, I am for the respondent.
Any objection?
No objection, but let a date be fixed, Lordship. In the next date, we hear the petition.
Learned
Maybe 27 April.
27.
27 April, Lordship.
Learned Counsel, Learned Government Advocate, Senior Government Advocate, Mr. N. Nangami, prays for listing the matter after 2 weeks as Mr. V. Zimomi.
No, Your Lordship, K. Angami.
Mr. K. Angami who is appearing in this matter, is in bereavement. Stop. Learned Counsel for the petitioner as well as the Learned Counsel for respondent. You are for Mr. Sarif?
Respondents 1 to 7.
1 to 7 has no objection. This is the matter on 27/4.
Lordship.
27/4. Yes.
Much obliged, Lord.
Deeply obliged.
Deeply obliged, Lordship.
Please, my lady.
Yes.
I beg to mention item number 14. Lady here, as per the office note, service report on the sole respondent is still awaited. So maybe if
So,
this matter can
2
come up
weeks?
after 3 weeks, my lady.
Okay. Learned Counsel, Ms. Lucinia, appearing for the petitioner, submits that the service report on respondent number,
sole respondent.
on the sole respondent is still awaited. So list after 3 weeks,
In the meantime,
awaiting
yeah.
service report on the sole respondent.
There's an
And-
interim.
And the interim order passed earlier shall continue till the next date of listing. Yes.
Obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 15 and 16.
15 and 16. Hearing, oh no, orders. Yes.
I've been instructed to appear for respondent number 5 in WPC number 22 of 2026. There is item number 15. Lordship, 3 weeks may be granted to us to file vakalatnama and affidavit in opposition.
Learned Counsel for the petitioner, Ms. Upang Longcher is present. Miss, your name, such and such. Please give your name. Yeah. Submits that she has received instructions to appear on behalf of respondent number 5 and therefore prays for how much time? 3 weeks.
3 weeks.
3 weeks time to file her vakalatnama and the affidavit in opposition. So prayers are not list after 3 weeks. Who's appearing for the government?
Ma'am, as Mary, I've informed her, Lordship.
Okay.
Obliged, Lordship.
For admission, item number 5.
Lordship, this matter is fixed for hearing of preliminary objection raised by the respondent. Also have some difficulties today. If this may be taken up on Friday, subject to convenience of this honorable court.
Preliminary objection.
The mental liberty of the appeal.
You have filed written objections?
Yes,
Or-
Lordship. Preliminary objection.
Okay, okay. Heard Learned Counsel for the appellant, Mr. Mohan Jamir, who submits that he has some difficulties today and therefore prays for listing the matter on Friday,
27.
27th. It's okay, on 27th, 3, for hearing on the preliminary objections. List on Friday according.
Much.
Item number 7.
Your Lordship, items 7 and 8 are similar matter out of an FIR. So in item number 8, I'm representing the respondent number 2.
7 and 8 are analogous.
Lordship, 8 is challenge to the FIR,
Okay.
and 7 is non-bailable warrant challenge.
Okay.
So in item number 8, I have respondent number 2. We will be filing our affidavit today. I've already served copy to the.
Okay, okay. So, when do you want? After a week?
If they don't file reply, then we can go for hearing.
Lordship,
Admission hearing.
I have just received a copy, so I need some time. So kindly list this matter on 17th of April.
17th of April.
Yes, Your Lordship.
Learned Counsel for the petitioner, Ms. Taikulo is present. Stop, Mr. I. Jamir. Learned Counsel appearing for respondent number 2. This will be in item 8, na?
Item 8. Lordship.
Appearing for the respondent number 2 in criminal petition 37 of 2025.
38 of 2025.
Okay. 38 of 2025 submits that he has filed his written objections.
We will be filing today.
That he will be filing the written objections during the course of the day. So Learned Counsel for the petitioner, Ms. Taikulo, submits that she would like to receive instructions regarding the objection filed by the respondent and therefore prays for listing the matter on 17/4/2026. Stop, praise aloud. List on 17/4, spread 4. This will cover both 7 and 8, okay?
Lordship, this interim will continue.
In both.
Yes, Your Lordship.
Okay, the interim order passed earlier shall continue till the next date.
Obliged. Lordship.
Item number 9.
Yes.
Yes, Lordship, trial court record already here.
Okay. Paper book prepared? Not yet, no? Learned Counsel for the petitioner, Ms. Such and Such is present. Mr. Nongosa is present for respondent number 2. What about PP?
I think he's absent.
Learned PP, Mr. Vijimomi is absent. Stop. The trial court records have been received from the court of Learned Special Judge FTSC Dimapur. Stop. Accordingly, the registry is directed to prepare the paper book and thereafter list the matter immediately upon preparation of the paper book for hearing. Yeah.
Much obliged.
Item number 10. Item number 10.
None appears for the petitioner when the matter is called list after 1 week. Yes.
Item number 11.
Please, Your Lordship.
Yes.
Lordship, as per the office note, service awaited upon respondent number 4. So kindly adjourn 4 weeks time.
Respondent 4.
Yes.
Your Ladyship, I appear for respondent 1.
Yeah, 1 minute. You just check up the office note dated 6/11/2025. Okay, it says something that if it was tracking was done and then in the communication dated 16/10 such and such, it is stated that both consignments were delivered to their respective branch office. Respondent 4 is the insurance. Who is respondent 4? Oh, respondent 4 is the vehicle owner.
Vehicle on.
Okay, we'll give them one more chance then. Learned Counsel, Ms. Taikrula appears for the appellant. Mr. Nongusa is present for the respondent number 1. Stop. The service report on respondent number 4 is still awaited. So accordingly, list after 3 weeks awaiting service report on respondent number 4. After that, if they don't appear, we can proceed.
Yes, Your Lordship.
Item number 12.
May I please, my lady?
Yes.
My lady, I beg apology for inadvertently missing to take steps upon respondent number 6 and 7 as directed by this honorable court by the order dated 26/2, my lady. My
Yes,
lady,
we're supposed to take fresh steps on 6 and
yes,
7.
yes, yes. It
Not
has
yet
been missed.
taken.
Inadvertently, I have missed it, my lady. I beg apology for that. If my lady may grant me 2 days, I'll be taking within 2 days, my lady.
Within a week. Within a week.
Okay. Yes.
Learned Counsel for the applicant, Mr. V. Devnath is present. Mr. Nongosa is present for respondent number
1 to 5.
1 to 5. So the Learned Counsel for the applicant submits that he is yet to take the fresh steps upon respondent number 6 and 7. And he prays that he may be given 3 days time to take the steps. Stop. Accordingly, list the matter after 1 week. Okay, within 1 week it will.
Deeply, deeply.
Item number 13.
May it please Your Lordship. Lordship, I'm appearing for, on behalf of Mr. Akru Chusi, the standing counsel for respondent 4, 5, and 6. Lordship, in the last occasion, this court has directed for completion of service to respondent number 7, which the report is ready. However, we are yet to obtain signatures on the Bakalat Nama, which is why it got rejected. So another 3 weeks time may be given.
Who's for the petitioner? You're for the petitioner.
By order dated 3 February 2026, the service upon respondent number 7 was to go through respondent number 5.
Learned Counsel, Ms. Minosen is present for the petitioner. So Learned Counsel, Ms. Asana Nkomer appearing for respondent number 4, 5.
On behalf of Mr. Akru Chusi, the standing counsel.
Okay. No, but 4, he's 4, 4, 5,
Five
and
and
6, isn't
six,
it?
yes, Lordship.
Appearing on behalf of Mr. Akriu Chuse, Learned Standing Counsel for respondent number 4, 5, and 6, submits that. What is your submission?
Lordship, the service report is completed. However, in the Vakalatnama, we are yet to obtain signatures of the two respondents.
Which respondents?
Respondent 4 and 5.
Okay. Submits that the signatures of some of the respondents is yet to be obtained, and therefore prays that the matter may be listed after how many days? 2 weeks?
3 weeks, Lordship.
After 3 weeks. Stop. What about you? Mr. Chin Yang Pong is present for respondent number 1. What about your affidavit?
Lordship, we are yet to receive instructions.
Okay. And submits that he is yet to receive instructions, and also prays for some time to receive the same and to file the affidavit in opposition. Accordingly, list the matter after 3 weeks.
Much obliged, Lordship.
My lord.
For hearing item number 17.
My lord, I wish
Item
to
17.
mention, hearing item 19 and 20. ma'am. We have,
Why,
in
why
fact,
now?
praying for
You're
2
praying
weeks'
for
time.
adjournment now?
Adjournment.
Why
My
not at the mention hour? What happened?
I was in the court number 1.
No, someone could have come. How many government advocates are there in the panel? 17, 18? Not even one could come.
We have prayed for
Why,
2
when
weeks'
the
time.
hearing matter is called, why mentioning now? What happened, 1920?
My lord, I was directed to file IA for implement of Marangpong Village Council. In fact, we have filed, but it was due to some defects. It was rejected. So we have rectified it, and then within the course of the day.
Direction was given by the court to
Yes, my lord.
implead.
Yes, my lord.
Already 2011, 2024.
What did you say? You filed it and it was defective.
Yes, my lord.
So you have refiled,
Yes, my lord. Within the course of the day.
or you'll be filing today.
Yes, my lord.
Then when can we list it? Tomorrow?
My lord, let it come up on Friday.
Learned Additional Advocate General, Mr. L.T. Sanctum, submits that the affidavit for implement of the Merangkong Village Council had been filed, but the same was rejected in view of some technical defects. And he submits that he will be filing the corrected IA. It
Yes,
is
ma'am.
corrected IA during the course of the day. So accordingly, he prays that the matter may be listed
On Friday.
on Friday. Give the date, okay? So Learned Counsel for petitioner, Mr. Moa Jamir is present, and also Ms. Apila Sanctum for the respondent number 9 and 10. Respondent number 9 in WP 236 of 23 and respondent number 10 in WP 321 of 2023 is also present. Stop accordingly list the matter on 27. 27.
Good day.
Item number 17.
Please, Your Lordship. My Lord, I am appealing for the petitioner in this case. By the last order measure, order dated 17/10/2023, CD was available with the public prosecutor, but the FIR was not available there. So time was sought for. I hope today the PP has the case diary with the CD, madam.
Who's appearing? BP.
BJ.
Oh. But he hasn't been
Last or-
this week, actually. He's around. Okay. Yes. Yes, Mr. Sakya.
9/6/2025, that order was to accompany the FIR along with the case diary, because in the entire records, my lord, the FIR is not there. Though I had received notice way back under section 41, way back on 11/12/2022. But it was not registered as a police case, and it is not even placed before this honorable court. So therefore, the order was passed on 9/6/25, so that FIR at least can be placed before this court. Now, case is very simple, my lord. If I am permitted to, my lord, start with.
Yes.
My lord, then letter of acceptance was issued by the PWD department, my lord, in favor of one Kampung proprietorship concern, my lord. That LOA is at page 52.
52. Yes.
Then your lordship will kindly see, my lord, the second last paragraph. You are also requested to furnish performance security for an amount of rupees 41,26,255 on receipt of this letter of acceptance. In case of delay, so and so, so and so. Now he has submitted the, my lord, this performance guarantee. Lordship will find at page 60.
60.
60. This has been submitted by the, my lord, Kampung Kamyang Trading Limited. With due respect and the subject matter above, we are submitting our performance guarantee, BG number so and so, BG amount of rupees 41,26,000. Therefore, we would be much obliged if you, esteemed department, accept the PBG so and so. Now, so far as the petitioner is concerned, my lord, he is also in the similar trade of, my lord, executing infrastructure projects. So has a good relation with, my lord, this Kampung Kamyang, who, my lord, happens to be, my lord, from state of Arunachal Pradesh. So to facilitate, my lord, the various official works of signing the, my lord, various documents, etc., he has given an, my lord, authority letter to the, my lord, present petitioner. Your lordship will find at page 61. It's a, my lord, proprietorship firm, and the present petitioner is one of the, my lord, partner, my lord. It's a partnership firm, my lord. Sir, we have received an email from your office dated so and so to our concerned representative mail ID. Hence, sir, we would like to authorize following two persons to attending all meetings and concern of the above mentioned project, namely Avilas Kishore Kashyap, who is the present petitioner of your lordship, and Thangchung Mar, Director Administration of Messrs. Jellyhu and Sons. Therefore, we urge you to kindly accept the authorization letter, which will also be replaced during the signing of the contract agreement as per power of attorney signing bid and appendix 3. Now, so far as, my lord, this authorization is, my lord, concern is pre-execution of the agreement. Once, my lord, execution, the agreement is executed, I will have nothing to do, my lord. And so far as the, my lord, the deposition of the bank guarantee, lordship has seen, it is the directly the contractor who has, my lord, submitted it. Now, my lord, the private respondent number 2, the work being in the Nagaland and he hailing from Nagaland, he wanted to execute the work as a subcontractor from, my lord, Kampung, the principal contractor. But then authority cannot allow because he doesn't have any, my lord, experience to execute such work. So therefore, my lord, at the, my lord, request of the Kampung, my lord, I have come, my lord, entered into an agreement with the present respondent number 2, my lord. Your lordship will find, my lord, that agreement is
Yes.
at page 65. This is agreement dated 22nd day of December 2021. Jelly and Sons. Now, entire would go to show, my lord, it's all with the principal contractor or the owner. Now, only clause which, my lord, is important here would be the clause number 8 at page 70.
Yes.
The bills for the work executed by the subcontractor and principal contractor jointly will be submitted to the owner. Owner is the government, madam. And on receiving the new payment of bills, after deducting all the taxes as the and any other deduction in the bill from owner, the payment will be made to subcontractor by deducting 2% of each RAR bill amount paid by the owner from each payment to facilitate the smooth functioning of the project. So this 2%, my lord, of the RAR bill, that is running account, my lord, bills, that will come to me. Rest is between the principal contractor and the subcontractor. After deducting this 2%, remaining will go to the my lord, subcontractor. So that's how I used to facilitate my technical know-how and then arrange the necessary, my lord, instrument implementation, etc. And the payments are to be done by him. Now, my lord, while scrutinizing the, my lord, this, my lord, the bank guarantee, the government found, the authority found that this, my lord, the bank guarantee are, my lord, fake and fraudulent, my lord. So therefore, a notice was issued, my lord, lordship will find, my lord, page 90.
Which bank guarantee? The one which was given via
The Kampung,
T2, page 60.
lordship, page 60, my lord. These two submitted by the Kampung as due performance of the contract. This was submitted by Kampung. That was found to be, my lord, fraudulent, etc., my lord.
Found to be fraudulent. Okay.
Lordship, my lord. At page 90, so a show cause notice was issued to the, my lord, owner, my lord.
90.
Page 90.
Okay.
Lordship, my lord. In inviting a reference to the subject cited above, it has come to the notice of the undersigned the submission of fraudulent documents, that is, performance bank guarantee by your firm, which is in violation of the contract agreement and account to contractors default and termination as per Article 22 and Article 23 of the agreement respectively, and shall further lead to blacklisting of the contractor as per Section 4 of the RFP. You are thereby requested to give your reply to this so-called notice within 15 days from the date of issue of this letter. Please note that in case no cause is shown by you within the stipulated period for the cause shown is not to the undersigned satisfaction, the authority shall take such action against you under Article 22, Article 23, and Article 23(1) of the contract agreement and Section 4 of the RFP and or other clauses thereof without further notice. Now, my so-called reply was submitted by the Kampung Miller, but this was not satisfactory, and ultimately page 98
Yes.
page 98.
Terminated.
The contract has been terminated. And the debarment notice was also issued, my lord, at page 99. So consequence upon this, my lord, termination and debarment, my lord, the respondent number 2 has suffered. But so far as I was assisting and giving my technical know-how and aiding him in execution of the work, I have, my lord, at my own risk, my lord, I have my lord, deployed certain machineries, etc. there. Now, when I had asked for all those, my lord, I have received a notice from the police. Your lordship will kindly see, my lord. I have received the, my lord, complaint at page 101.
101. Yes.
101. It's a notice under section 41. May I read, my lord?
Yes. Please read.
Whereas a criminal case is undergoing investigation at East Police Station, Dimapur, Nagaland, by East Police Station GD number dated so and so, wherein a reasonable complaint was filed by Razali Nagi, that is respondent number 2, House number Soro, Dimapur, stating to the effect that a project for development of existing two-lane pavement, including straightening of NH 36 from so-and-so to so-and-so kilometer in Dimapur, was awarded to Messrs. Kampung Kamyang Trading Company, Laharagun, Papumpaya, Arunachal Pradesh by the Government of Nagaland, Office of the Chief Engineer, NH PWD Kohima, at a cost of rupees 13 crore 75 lakhs 41,810 only. In this regard, on December 2021, you offered to jointly execute the said project with Messrs. Rosali Nagi Farm, and you made to believe that you are the legal representative and authorized signatory of the aforementioned firm, Messrs. Jelihu and Sons. You further represented that Messrs. Jelihu and Sons was going to execute the said project for and on behalf of Messrs. Kampung Kamyang Trading Company. So, in order to convince the complainant, Mrs. Rosalie Nagi, you produced a handed over copy of the letter of award bearing number so and so dated so and so. Accordingly, a subcontract agreement bearing registration number so and so dated so and so was executed between Jelihu and Abilas Kashyap and Messrs. Rosalie Nagi. Thereafter, another memorandum of understanding was bearing registration number so and so dated so and so was executed between the same parties. Meanwhile, the complainant had made monetary investment to the tune of about 2.4 crores in the said project, while the complainant, Mr. Rosalie Nagi, was sincerely executing the said project in terms of the aforesaid agreement and the MOU. He was shocked and appalled to learn that the said project has been terminated by the Office of Chief Engineer PWD NH Nagaland Kohima by termination notice dated bearing number so and so dated 27/7/2022. In this regard, it has been mentioned that said letter of award dated 22/10/2021, as well as the aforesaid agreement, you, the authorized legal representative of Kampung Kamyam Trading Company, as well as managing director of Messrs. Jelihu and Sons, was responsible for depositing the performance security of 41,26,000 so and so. And now it has transpired that the said performance security, also known as performance bank guarantee, deposited by Abilas Kashyap, was taken as false. It is absolutely, my lord, false statement apparently on the face of the record. Lordship has seen, my lord, the page 60. It has been deposited by the Kampung. And the agreement your lordship has seen, I have never represented myself to be the representative of Kampung. It is only to show the technical know-how this subcontract agreement was executed that will be jointly will be doing it, and the that particular payment clause will go to show that I receive only 2% of the RAR bill. Rest entire goes to the subcontractor, respondent number 2. Now the entire blame has been sought to be given on me, by saying that those FD has been deposited by me. Now, further going to the notice, my lord, you did not report before the undersigned earlier on 11/12/2022, hence a second reminder has been issued. It appears that this is the second notice issued by the police. The first one I did not receive. This is the first one, so far as I am concerned, my lord. So before I could, my lord, reach, my lord, before I could, my lord, because this was, my lord, received lately, so, my lord, I could not, my lord, attend the, my lord, police. Then I received, my lord, the third one, my lord, at page 103. This is a third reminder by the police, but more or less stating these same things. Now, my lord, being apprehensive
Yes.
with these, my lord, things, I have approached the, my lord, honorable court for grant of a, my lord, anticipatory bail to me. And Lordship will find at page 109.
109.
9, Lordship, my lord. Now, I was granted, my lord, interim bail. The page 110. The learned PP shall produce the necessary instruction, my second paragraph. The learned PP shall produce the necessary instruction before this court on 10/4/2023. Pending the production of the instruction by the learned PP, the petitioner shall be released on ad interim pre-arrest bail on the following terms and conditions. The petitioner shall appear before the officer in charge East Police Station on 23/3/2022. The petitioner shall be released on executing a bail bond of rupees so and so, so and so. My lord, I appeared, my lord, pursuant to this. This is a condition, my lord. I had to appear, so I have, my lord, appeared before the, my lord, police on 23rd. And what happened, my lord, on 23rd? Your lordship will come to, my lord, page 115. In the police station itself, page 111.
115.
115, my lord. I'm sorry. Is dated 23rd day of March 2023. And this should reveal that this was, the, my lord, while I was in the, my lord, police station. This would reveal from subsequently. Now, what happened by this agreement, my lord? They have made to sign and, my lord, this agreement by undertaking to pay certain liability. That your lordship will find. Second paragraph onwards, your lordship may kindly page 116. Page 116.
116. Yes.
Second paragraph onwards. In the month of December 2021, the second party offered to jointly execute the said project with the first party firm Messrs. Razahin Nagi. Further, the second party represented before the first party stating that he is the legal representative and authorized signatory of Messrs. Jalihu and Sons, and was going to execute the said project for and behalf of the Kampong Trading Company. Accordingly, second party produced and handed over a copy of the letter of award bearing so and so, dated so and so, to the first party. Subsequently, a subcontract agreement bearing registration number so and so was executed by Jalihu and Son, represented by second party, and first party. Thereafter, another MO bearing so and so was executed between the parties. Meanwhile, the first party have made monetary investment to the tune of rupees 2.4 crores rupees this project. While in the process of executing the said project, it was learned that the said project has been terminated by the office of the Chief Engineer PWD Nagaland Kohima by termination notice dated so and so. A termination notice dated 27/7/22 has been issued by the concerned department due to performance security, also known as performance guarantee, deposited by the second party, authorized legal representative of MESAP Kampong Kamir Company, as well as managing director of MESAP Jalihu and Sons, to be fake and false. In the regard, first have lost FIR on 19/2/2022 at police station Dimapur, Nagaland against the second party. Now, therefore, the undertaking witness and the parties here to agree is as follows: that the second party has agreed to pay rupees 30 lakhs, that is me, 30 lakhs to the first party on or before 10th April 2023. That the first party has agreed to give a grace period to the second party, 7 months time, with effect from 10/4/2023 to 10/11/2020 to pay remaining amount. That the second party shall not have liberty to waive the liability responsibility of the said amount after grant period whatsoever. That the first party will have the discretion power to extend the grace period after the grace period is over on 10/11/2023, and will have all the rights to take appropriate legal action against the second party in competent court of law if the amount is not paid on time. Well, this was on coercion, this was on forceful, this was within the custody of the police. So therefore, after once I have signed this document, I was allowed to I was released, I was allowed to go out of the police station. Then I have made a correspondence that actually happening, things was to be compromised, and you had written into this way. Accordingly, I have submitted my letter to this respondent number 2 at page 116. He has also disputing the facts. He has also replied by page 121. And since he has denied I have filed a title suit. I have filed a title suit before the competent court at Gauhati. And that suit is pending, TS number 298 of 2023, where the respondent number 2 is also appear, madam. Because this is basically an agreement. Even if it is taken on the face value, it is an agreement. So agreement, which was which was executed under force, under coercion, and under undue influence, so therefore that has been challenged before the court. Now, in the meantime,
This agreement of 23rd March 2023,
no, Chief Miller.
the title suit is with regard to this.
No, Chief Miller. Entire dispute, he has also released another agreement therein. So that is also, a challenge. And in the meantime, this court, in the bail application was, my bail application was made absolute at page 111. May I read, Mr.?
Yes.
111.
Yes.
Paragraph second onwards. This application under section 438 of CRPC 1973 has been filed by the applicant seeking pre-S bail in connection with GD entry number so-and-so of East Police Station, Dimapur, Nagaland. The basis of apprehending arrest is the notice under section 41A of CRPC 1973, by which the police has issued to the applicant stating that a criminal case is undergoing investigation at East Police Station, Dimapur, Nagaland, GD number so-and-so dated 29/11/2022, wherein a complaint was filed by one Rojali Nagi relating to project development of existing two-lane pavement, including straightening of NH 36 in Dimapur, which was awarded to Messrs. Kampong Kamyang Trading Company, Papunala, near Diet Building, Julie Road, POPS Naharlagun, Papumpare, Arunachal Pradesh. The applicant is shown to be authorized legal representative of Kampong Kamyang Trading Company, as well as managing director of Jolehu and Sons, which was stated to be responsible for depositing the security of rupees 41 lakhs and odd only, and it also alleged that the said performance security known as performance bank guarantee deposited by the applicant was fake and false. Mr. So-and-so, for the applicant submits that applicant is apprehending arrest by police in view of the two notices issued under 41 CRPC by the officer in charge, so-and-so Nagaland on so-and-so, and 25/1/2020. He submits that the applicant was authorized legal representative prior to the contract agreement that I have shown in page 61. I was authorized only to execute certain documents till the contract agreement is signed, not beyond that. The learned senior counsel submits that the applicant is no way connected to the execution of work. There was an agreement with the informant to the extent of providing technical support and credential to the authorities if required. There is no question of submission of performance bank guarantee. Therefore, the applicant is not at all connected with the allegation. This court on 23/3/2023, pending production of the instruction by the learned public prosecutor, has granted pre-S bail on the following condition. Petitioner shall appear before the officer in charge East Police Station station on 23/3/2023. Then are the other conditions. Then Lordship may come to page 114. The learned public prosecutor produced a scanned case diary today. Relying on the scanned case diary, the learned public prosecutor submits that the inquiry officer of the case, East Police Station, Dimapur, has closed the miscellaneous case diary. East Police Station, Dimapur, has closed the miscellaneous case diary at East Police Station for other law and order duty, wherein it is stated that henceforth an agreement was executed between the parties and they have decided to follow up with the agreement terms executed on 23/3/2023. The agreement has not been done under any coercive manner, where it was made willfully and voluntarily by both the parties. It was further stated that FIR has not been withdrawn yet by the complainant, as the condition of the said agreement cites that any failure to the agreement made thereof by the Avilas Kishore Kashyap will lead to a lawful course of action. However, the said submission relied on the case diary is disputed by the learned senior counsel for the appellant. On consideration of the submission of materials placed before the court, this court finds that in view of submission indicated above, no custodial interrogation is required. Thereof, the court deems it appropriate to allow the applicant. Accordingly, the interim order granting bail by this court on 23/2023 is made absolute with the same terms and conditions. Now, what it transpires from this order, your lordship has seen, my lord. Police has admitted execution of the agreement on 23/3/2023, and then parties will abide by the terms and condition of that agreement. So the criminal investigation is no longer required. It become a purely a civil, and for which a title suit has already been instituted. Where the other side is also contesting. But further it has been said, as the FIR has not been withdrawn, so if the agreement is not followed, then legal action will be taken. As if, my lord, the police is acting as an executing, my lord, court, or rather, my lord, my lord, the civil judge, that if the agreement is not followed, then we'll know how to execute it. So we'll execute the procedure. Now this bail has been, my lord, made absolute, and thereafter, what happened, my lord? At page 123, I have again received another notice from the police.
This is on 11/5.
11/5/2020. This is again under 41A CRPC. This is under challenge before this honorable court as well as the proceeding. Now, what is there in this, my lord, notice, your lordship, will absolutely, my lord, malafide, my lord. It is the beyond the police, my lord, duty, my lord. I'll come to, my lord, my
Please.
lord, yeah, my lord, will find, my lord, page 123, second paragraph onwards. In this regard, you have appeared before the investigating agency on your own date and time, that is 23rd March 2023, despite respecting the police notice under section 41A CRPC directing you to appear on the specific date and time. However, on appearing at East Police Station, you have discussed with the complainant of the case, Mr. Rajelu Nagi, and amicably decided to come into terms and executing the agreement dated so and so. Pausing for a moment, when I had appeared on 23rd, how the Rogelio Nagi had come to the Marat police station? Who has informed him? How he could be, my lord, coming there inside the, my lord, and under the nose of the police, my lord, agreement was executed. The police ought to have said, if you have compromised, you go and make a deed of agreement and settle it. And you submit, will submit a final report accordingly. But no, it was the police who has intimated them, they have come, and then under pressure, duress, etc. So and so this has been done. Then, my lord, continuing again, my lord. And as such, no sort of forceful act or coercive manner was against you to sign the agreement, as it was done in your own will of mine to come into terms, whereas it can also stated that you have agreed to pay rupees 30 lakhs on complainant. So call first party on or before 10th April 23 and remaining about so and so so and so. Hence, it was learned that you have diverted your mind after going back to Guwahati, Assam, and as per agreement executed between you and Rosalie Nagi, you haven't paid a single penny to Rosalie Nagi since the FIR is still active, and as per the agreement declared that it will have all the rights to take appropriate legal action against you if the amount is not paid on time. You are fully bound to face legal action. Hereby, a notice is issued directing you to report to appear before the undersigned on or before 20th May 2020 at so and so at so and so. It is hereby informed that inform you be this notice that if you fail to comply with the above notice, then you will be produced before the competent court by me in the above offense as per the provisions of law. Matlab that police is acting as an executing court of the agreement. Not only that, this court has granted me interim bail as well as the bail has been made absolute.
Yes.
Now still the police is saying that if I fail to appear before them, they'll catch hold of me and they'll produce me before the competent court. But the procedure is well known, my lord. If a bail condition is violated, in that case, you have to come to the court and get the bail cancelled for the reasons whatever you assign, and then you take me into custody and do whatever you do.
Police is saying that you have to pay.
You pay. You have agreed, so you have to pay. Whether it is, I am liable to pay the documents on the face of the records, Lasiba said, page 60. It's a kampung. No action has been initiated against the that kampung Khmer of Arunachal. Just because I am a small fry, they can catch me at any time here. So they are the police as well as the respondent number 2 in league are after me. Let the CD perhaps will be there. Let's see, we'll see what actions they have taken against Kampung, who has deposited the forged document. And in fact, Lordship will find an additional affidavit I have filed. It was dated 14/11/2024.
Yes.
Now, here, Lachit may turn to internal page 6. Perhaps the running page will be 132, internal page 6. For the same incident of the fraudulent of forgery of this bank guarantee, the concerned chief engineer at column 5, your Lordship will find the chief engineer PWD NH Kohima, Nagaland. He has lodged an FIR. And your contention is at page 8. Complaint against Messrs. Kampung Kamyang Trading Company for submission of, has your Lordship got it, page 1, internal page 8.
Yes, page 8.
Page 8. This is the body of the written complaint by the chief engineer. And the subject is complaint against Messrs. Kampung Kamyang Trading for submission of bogus forgery bank guarantee so and so. In inviting a reference to the subject cited above, it is stated the following. The Ministry of Road Transport and Highways sanctioned the work development of existing two-lane pavement, including strengthening of NH 36 from kilometer so and so in Dimapur city portion in the state of Nagaland, by letter number so and so, dated so and so. Mr. Kampung Kamyang Trading Papum Nala near Diet Building Juli Road, Naharlagun Papumpare, Arunachal Pradesh has submitted its bid for the work mentioned above by letter dated 4/8/2021, which was invited by the chief engineer Nagaland by so and so so and so. PWD NH division by letter dated 22nd October 23 has issued the LOI in favor of Messrs. Kampung Kamyang Trading Company at the contract price of so and so 10,000. Also informing to submit the performance security for an amount of 41.26 lakhs to 255 only, as per clause 2.21 of RFP, within 30 days of receipt of the LOI so and so. Mr. Kampung Kamyang Trading has submitted the performance security height BG number so and so, dated so and so, for an amount of rupees so and so, through the Bank Maharashtra, Badalpur branch so and so. PWD, in receipt of the confirmation of the performance bank guarantee by letter dated, had accordingly signed the contract agreement with Kampung Kamyang Trading, Papumpare, Arunachal Pradesh, so and so date. Under direction from the MOT to get the performance bank guarantee physically verified from the issuing branch, an officer from the state PWD was deputed. The Maharashtra deputed to Thane, Maharashtra, for physical verification of BG from the zonal office of the Bank of Maharashtra on 28 June 2022, wherein non-confirmation of the performance bank guarantee was received on 20th June 2022. The PWD NH by letter dated 5th July 22 had issued so-cause notice to make a representation within 15 days. Messrs. Kampung Kamyang Tabra has submitted their representation via letter dated 11 July 2022. However, the reply given is unsatisfactory and are not justifiable and acceptable. PWD via letter dated 27 July 22 has issued termination notice to Messrs. Kampung. In view of the above, PWD and the public Nagaland in general have been deprived of completing the much awaited development project under the Dimapur city. Therefore, it is requested kindly to treat the complaint as a first information report against the Kampung Kamyang Trading Company and initiate appropriate action as per relevant provision of submission. From here, it is clear. LOI issued to Kampung. Request was made to Kampung to deposit the performance guarantee. He has deposited the performance guarantee. Now, after the verification of the BG having found that these are not correct, so-cause notice was issued to the Kampung. Kampung has submitted the so-cause reply, and thereafter the contract has been terminated. It is unclear, and it is an official person, my lord, who has been sought to be cheated. It is the NH, the PWD, my lord, who is sought to be cheated or with whom the fraudulent act was committed. And more particularly, your lordship will find this FIR was lodged on 3/8/2022.
3/8.
3/8/2022. And from the notice, your lordship will find notice issued to me. Your lordship will find even in the page 101.
It is 12/1/23. Yes, 12/1.
GD 12/9/2022. And the complaint, the instant complaint by the chief engineer was submitted on 3/8/2022.
22.
So this is a second complaint which has been lodged by respondent number 2, which is barred in view of the decision in the Amitabh Bhai Anil Chandra Shah. There cannot be any second FIR. I'll come to that decision, my lord.
This FIR, which you have shown just now in your additional affidavit, is 3/8/22. Isn't it?
22.
3/8/22.
Lordship. And this has been registered on 5/8/2022. Page 6.
And then the FIR in respect of the petitioner, when was it lodged?
There doesn't till date we have not seen the face of the FIR. That's why on the last occasion the
Last occasion,
council said Counsel said the CD is not accompanied with the FIR, so he wanted to have the up-to-date CD with the FIR.
Yes, yes.
Now from this notice dated 101, your lordship will see the complaint that was lodged by the respondent number 2, page 101 of my petition.
Yes.
The second line, whereas a criminal case is undergoing investigation is at Dimapur, which is station GD number 6 of so-and-so dated 12/9/2022. So GD is the first, my lord, the steps of registering a case. After the GD, normally a preliminary inquiry is done and thereafter the regular FIR is being registered. Now, from the entire recitation of these notices, your lordship will not find under what section this GD has been registered. We have not seen, my lord, the FIR under what section, my lord, this complaint has been registered. First of all, my lord, the second FIR is not mental. Apparently, my lord, when on the face of the FIR dated 5/8/2022 in Kohima PS case number 26 of 2022 under section 467, 465, 420, 468, 471. Any complaint relating to the same incident cannot be registered by any police authority as it is, my lord, second FIR.
GR 202. Okay, so the first FIR dated 3/8/2022. This is Kohima PS case number
26 of 2022. Well, also will find page 6 of the additional affidavit.
Yes, 26 of 2022.
22. And this has been registered under section 467, 465,
20.
420, 468, 471. Now the GD entry that has been, my lord, made on the basis of the complaint by the respondent number 2, the police is investigating under which offense? It is not nowhere mentioned in this, my lord, notice. This is the second notice, even on the third notice also. It does not reflect. In the last notice also, it does not reflect. Rather, the last notice, what it reflects, the last notice reflects that there is an agreement. I have violated. So they are the executing authorities. Since I have violated, so FIR is still there. We'll execute. You come on so-and-so date. We'll again put you behind. And unless you pay the money, we'll keep you inside the bar. Notwithstanding this court granting me the absolute bail.
Okay. Yes, anything else?
Yes, madam. Now, question is, my lord, the two aspects, my lord. Firstly, I have said that second FIR is not maintainable.
Yes.
I'll cite the decision for that. And secondly, the story sought to be, my lord, projected or the offense alleged, absolutely concocted, my lord, absolutely with malafide intention, vexatiously instituted in league with the police only to harass me and extract the money, which I had never taken. Rather, my lord, we have the information, though, my lord, it has not been, my lord, brought on record, that about 80 lakhs of rupees has already been paid to, my lord, the respondent number 2 by the chief engineer. Of course, this is not on record. This is an information. Because of his executing the work. As per the agreement your lordship has seen, it is not that we'll be jointly working, jointly investing. The money clause will 100% shows that I'll be getting only 2% of the RAR bill. And because of my technical know-how, I have raised in my petition, your lordship will kindly see the paragraphs. Few paragraphs, madam. Firstly, my lord, your lordship will kindly further note, my lord. Uh, on 18/9/2023, the private respondent has said that he will not file any affidavit against the statement or the allegation, whatever I have brought in my petition. That is the order dated 18/9/2023.
18/9/2020.
18/9/2023.
Yes.
Heard Mr. So-and-so, state by so-and-so. For the petitioner also heard Mr. So-and-so, learned public official for the state, and so-and-so, learned counsel for the respondent to. Mr. So-and-so, learned counsel for the respondent to submits that he would not file any affidavit in opposition. Admit this petition, list for hearing so-and-so. So now coming back to the my petition, paragraph 5 at page 5.
Yes.
That the petitioner states that for execution of the aforesaid contract, the aforesaid Messrs. Kampung Kamyang Trading Company had arranged performance bank guarantee for an amount of rupees 41,26,555 in respect of LOA dated so-and-so, and performance bank guarantee of rupees so-and-so in respect of LOA Meghalaya through one Mr. Sisi Khan, and for that matter, on the request of Messrs. Kampung Kamyang Trading Company, the petitioner paid him a certain amount which was subsequently refunded. The petitioner states that this has not been denied. That the petitioner states that performance bank guarantee number so and so dated 22/11/21 for a sum of rupees 41 lakhs 26,555 had been forwarded by the concerned bank to the office of the chief engineer, Kohima, Nagaland through diesel pen. The aforesaid performance bank guarantee has been submitted by Messrs. Kampung Kamyang Trading Company via letter dated so and so before the chief engineer PWD. This has not been denied. Then paragraph 7, the petitioner states that proprietor of aforesaid Kampung Kamyang Trading Company had issued an authorization letter authorizing the petitioner and other director of the petitioner firm to assist him in preliminary work, such as attending the meeting on behalf of the said firm, and also signed the document on its behalf, and accordingly issued a letter dated 27/10/2021. The chief engineer PWD Kohima, Nagaland, intimating the authorization of the petitioner and Messrs. Thukchung Mar for attending all meeting concerning the said project, and further stipulated that said authorization letter shall be replaced during the signing of the contract as power of attorney signing bids. So this is authorization was up to the my lord signing of the contract bid. The contract execution of the contract starts only after my lord agreement is being signed. So whatever official formality, somewhere meeting I have to attend, something I have to do, my lord, for that purpose this authorization was there, which I have taken your lordship to the page 61. So this is admitted, not denied. Then paragraph 8, the petitioner stated that after receipt of the aforesaid bank guarantee, the chief engineer PWD Kohima, Nagaland, and aforesaid Kampung Kamyang Trading Company executed an agreement on behalf of the Kampung Kamyang Company. One Messrs. Razilu Nagi was to execute the work on the signing strength of a power of attorney issued by aforesaid Messrs. Kamyang Kampung Trading Company. The power of executed in favor of the respondent number 2 to execute the work. This has not been denied. Then paragraph 10, May I read paragraph 10, my lord?
Yes, 1 minute.
Yes.
Okay, paragraph 10. Yes.
Paragraph 10, page 8. The petitioner states that in the meantime, aforesaid Rogelio Nagi had approached Messrs. Kampung Kamyang Trading Company to allow him to execute the aforesaid project, but as said Rogelio Nagi, this is response number 2, did not possess the required credential and qualification for execution of the work. They said Rogelio Nagi approached the petitioner for utilization of the credential of the petitioner and to provide technical support to him, including supply of tools and machinery and other construction material. On such approach, with the consent of Kampung Kamia Trading Company, the petitioner on behalf of the aforesaid firm of the petitioner entered into a subcontract agreement with Messrs. Rajili Nagi, whereby both parties undertook joint responsibility of execution of the work, and in turn, the petitioner would be receiving 2% of each running account bill. This is not denied. Then again, my lord, paragraph 12. That it may be married.
Yes. Paragraph 12.
Paragraph 12. Lordship, that it may be mentioned that for the execution of the said project, joint account has been opened by Messrs. Razili Nagi and Messrs. Kampung Kamir Trading Company at Nagaland State Cooperative Bank, which has been submitted before the authority for making payment. However, till date, no amount has been released by the authority. It may be mentioned that although a joint account was opened in the name of petitioner firm and Razelu Nagi at HDFC Bank Dimapur branch, however, as no transaction was made in the said account was closed. Now, insofar as the account of this joint account of Messrs. Kampung Kamyang Trading and Razelu Nagi is concerned, well, my latest information is that rupees 80 lakhs has been approximately debited to that account for the works he has already executed. Now, police, what they are investigating, Lordship will kindly see, my lord. First of all, I have shown, my lord, that absolutely there is no case, my lord. The basic case is that deposition of the fraudulent
Bank guarantee.
bank guarantee. And admittedly, that has been, my lord, deposited by the my lord, this Kampung, the principal contractor, which is also reflected in the FIR of the chief engineer, who is the actual authority, who has been a aggrieved person for submitting this. He has said categorically that this was submitted by Kampung. Now, only to harass me, my lord, this FIR has been, my lord, done, and my lord, they have taking, my lord, my appearance on 23rd. They have got the agreement executed, which is under challenge in a TS before the honorable court, which is under the my lord, execution. Now, so far as, my lord, that is so far as the, my lord, factual part is concerned, my lord, may I cite few of the judgments, my lord, in this regard, my lord.
Yes, please give your list. Yes.
My lord, list, I think the citations were already submitted before the court on the earlier occasion. List of dates, my friend perhaps has given.
Okay, okay.
List of judgment.
Yes, it is here.
Judgment should be there, my lord.
Yes, they are here.
It is there, my lord. So I just said, my lord, first judgment on the duty of the police, my lord.
You just
AR
take,
19
yes, you just give the citation and then the para number and on what point.
Lordship, my lord. Yes, sir. My lord, should I make a list and submit, or I'll just
I think
my lord,
it's already here.
okay,
Yes.
okay. AIR 1974,
Yes.
Supreme Court 1822,
Yes.
Jamuna Chaudhary,
Para 11.
para 11. It is duty of IO is to bring out real unvarnished truth.
Yes.
That is the duty of the police, my lord. I'll not take your lordship to the concerned, my lord, relevant paragraph. Lordship will see, my lord, only to sorten out the things, my lord.
Then the other one is 2011 Criminal Law Journal, 1626.
16 to Harsendra Kumar.
Yes.
Public document on material which are beyond suspicion or doubt can be looked into exercise of power under section 397 or 482 of CRPC. Now here the FIR do not contain, my lord, this LOA. FIR do not contain, my lord, this the authorization letter do not contain the, my lord, the FIR lodged by the, my lord, the chief engineer, etc. All these documents are the, my lord, public document, my lord. So I am submitting, and those are without any objection. That has been admitted. So that can be relied on for the purpose of my lord, deciding the instant application, my lord.
Yes.
Then, Lordship, I am referring to, my lord, 2006 CILJ 2782 Ram Biraji Devi and another versus Umesh Kumar Singh and another. The averment of the complaint and witnesses would amount to civil liability and no criminal liability can be attributed. Now, your lordship has seen, my lord, that allegation of criminality is with regard to the fraudulency of the bank guarantee. That has admittedly not done by me. Now remaining the subcontracting, he is saying that the subcontracting part, what will happen? So if there be any, my lord, dispute with regard to the payment, it is a civil in nature. And more particularly, the document what they are now relying of the agreement dated 23/3/2023, which was signed in the police station. Coupled with the impugned notice dated 11/5/2023, it clearly appears that it is a civil dispute.
Yes.
Then I am relying AIR Online 2023, Supreme Court 602. Some more are given, but then, my lord, those can be skipped, my lord. AIR Online 2023, Supreme Court 602. Muhammad Ali versus State of UP. That is, will be CL number 7.
That one is not here in this compilation.
CL number 7, my lord, in the list.
No, serial number 7 is AIR 2014, Lalita Kumari.
Okay, perhaps a different latest has not gone, my lord. Anyway, I'll be supplying this, my lord, immediately citations, my lord, I'll be giving, my lord.
Maybe you have another list besides this.
Maybe, my lord. For a moment, my lord.
Yes.
Lordship has this AIR 2013 Supreme Court 3974. Amit Bhai Anil Chandra Shah.
Yes, yes. Versus CBI.
Versus CBI. I'm relying on para 20, 32, 52E. And in para 20, there can be no second FIR, and consequently there can be no fresh investigation on receipt of every subsequent information in respect of the same cognizable offense on the same occurrence of incident, giving rise to one or more cognizable offense.
TT Anthony is also there, second FIR.
Lordship, yes, second FIR on that is also there, madam.
Then?
Now, so far as AIR Online 23602 Muhammad Ali is concerned, my lord, what it says, my lord, from a reading, my lord, of the entire, my lord, FIR, here there is no FIR, but from the notice only after it will be reading coupled with the documents, my lord. Entire case put up was concocted and fabricated and liable to be, my lord, quashed, my lord. That judgment I will be supplying, my lord, during the course of the day. My friend will be, my lord, delivered to your lordship, my lord.
in 2023-20 SEC, which is the paragraph? It's a short judgment.
AIR Online 2023,
Yes, Mahmood Ali.
Supreme Court 602.
Huh.
Party's name Muhammad Ali
Versus State of.
versus UP.
Yes, yes.
It may be in SCC, Millard. I'm referring to the online.
I have the SEC copy.
Okay, Millard. There's Muhammad Ali versus State of UP.
Yes.
Yes, yes. Millard, perhaps the paragraphs are Millard 10, 11, 12, and 14.
It is not telling because here it is only till para 6.
I'll be supplying it one minute. I'll be supplying it one minute. I'll just read out only one paragraph of that judgment.
Yes.
Paragraph 12.
At this stage.
At this stage, exactly.
Yes.
We would like to observe something important. Whenever an accused comes before the court invoking either the inherent power under Section 482 of Code of Criminal Procedure or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, then in such circumstances the court owes a duty to look into the affair with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the avowment made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the avowments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the aforesaid offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into 13 many other attending circumstances emerges from the record of the case over and above the avowment, and if needed be with due care and circumstances try to read between the lines. This court, while exercising its jurisdiction under 482 of the CRPC or Article 227 of the 226 of the Constitution, need not restrict itself only to the state of the case, but is empowered to take into account the overall circumstances leading to the initiation and registration of the case, as well as the materials collection in course of the investigation. Only to make out a case of criminality, my lord, it has been said, I have deposited the bank guarantee, which turned out to be forged. Apart from that, nothing is there. And the attending circumstances, documents appended, it clearly shows it's absolutely a false and malicious statement.
Okay.
That is my submission, my lord, subject to my lord, what my friend submits, my lord. I may have to respond. But till that, my lord, I have not seen, my lord, the FIR, my lord, if any.
Yes.
May I please, Your Lordship? Lordship, on the last.
You have, if you have extra copies, you give them also, the FIR.
FIR.
going by the notices issued to the petitioner, it appears that there is an agreement regarding payment of certain amount.
Lordship.
So that amount perhaps was not paid by the, allegedly not paid by the petitioner. So in such a case, whether any criminal case can be registered, that is one question.
Lordship, in fact,
Because as far as the bank guarantees are concerned, it appears that it was Kampung traders who had deposited the same, not the petitioner.
Lordship, I will also come to that, Lordship. This is the FIR.
Okay.
I'm allowed to read the FIR.
Yes, yes. This is dated.
This is this is FIR dated 12/9/2022. Complaint. This is the complaint.
12/9/22.
Lodge.
Complaint is.
This is the complaint to the officer in charge, East Police Station, Dimapur, Nagaland. Subject: first information report regarding forgery, fraud, criminal breach of trust, cheating, etc. Sir, this FIR has been filed against one Mr. Abhilash Kasap, the managing director of MS Zelizer and Sons, having it registered office at house number 207, ground floor, Hangrabari, Main Road, near LP School, PO Hangrabari, PS Dispur, Gauhati, Assam, for forgery, fraud, criminal breach of trust, cheating, etc. A project for development of existing two land pavement, including strengthening of NH 36 from 160/00 kilometer to so-and-so kilometer in Dimapur city portion in the state of Nagaland. Hereinafter referred to as the said project was awarded to MS Kampong Kamir Trading Co. Near Dike Building, Julie Road, Nahalgon, so-and-so, Arunachal District, Arunachal Pradesh, by the Government of Nagaland, Office of the Chief Engineer, National Highway, PWD, Kohima, and the Ministry of Road and Transport Highways. The cost of the said project was rupees 13,75,41,810. In this regard, I beg to state that sometime in the month of December 2021, the above named Mr. Abhilash Kishore Kesap offered to jointly execute the said project with my firm, MS Razali Nagi. Mr. Abhilash Kishore Kasap represented before me and made me to believe that he was the legal representative and authorized signatory of the above named MS Zelisu and Son. Mr. Abhilash Kishore Kasap further represented before me that his firm, i.e. MS Zelisu Sons, was going to execute the said project for and on behalf of the name MS Kampong Kamir Trading Co. In order to convince me, Mr. Abhilash, very important, Mr. Abhilash Kishore Kasap produced and handed over to me a copy of letter of award LOA bearing number so-and-so, dated 22/10/2021. Accordingly, a subcontract agreement bearing registration number 636/2021, dated 22/12/2021, was executed between the MS Zelisu and Son, represented by Mr. Abhilash Kishore Kasap, and my firm, MS Razale Nagi. Thereafter, another memorandum of understanding bearing registration number 445/2022, dated 24/5/2022, was executed between the same parties. Meanwhile, I have had monetary investment to the tune of about rupees 2.4 crores only in the said project. While I was sincerely executing the said project in terms of aforementioned agreement and the subsequently executed MOU, I was shocked and appalled to learn that the said project has been terminated by the Office of the Chief Engineer, PWD NH Nagaland, Kohima, by termination notice bearing number so-and-so, dated 27/7/2022. In this regard, it may be pertinent to mention here that, as per the said letter of award dated 22/10/2021, as well as in our aforesaid agreement, Mr. Abhilash Kishore Kasap, the authorized legal representative of MS Kampung Kamya Trading Co., as well as the managing director of MS Zelise and Son, was responsible for depositing the performance security of rupees 41 lakhs 26,255 only. Now it has transpired that the said performance security, also known as the performance bank guarantee deposited by Mr. Abhilash Kishore Kasap, was fake and forged. Accordingly, the termination notice dated 27/7/2022 has been issued by the concerned department. I therefore request you to kindly register a case and prosecute the accused Mr. Abhilash Kishore Kasap as per the provisions of law. Thereafter, Lordship, FIR has been lodged. This is the FIR number 215/2023, dated 28/8/2023, under section 406/420, 465/467/468/471, Lordship. And Lordship, Lordship, here the petitioner is alleging that there is two FIR, Lordship. However, Lordship, this is the only FIR dated 28/8/2023, Lordship.
No, what about the other one, which is there in the additional affidavit? Annexure lodged by the chief engineer.
By the chief engineer, Lordship.
Yes. That is also same complaint against MS Kampung Kamya Trading
Lordship.
for submission of bogus forged bank guarantee. This one also.
Lordship, however, as far as
This one is 5/8/22.
Lordship. However, Lordship, this is the only FIR, Lordship, that we have been registered, Lordship. 28/8/2023, Lordship. Lordship, moreover, Lordship, there is a same FIR which has been lodged before the
Kohima PS. Kohima.
in the state of Meghalaya, Lordship. Lordship, I would like to produce that on against the same person. If I may allow to read. To the officer in charge, Medanmin Police Station, Shillong, subject FIR. Sir, Madam, respectfully, I, the undersigned, would like to state that I had to buy bitumen from one company, namely Bitumex India LLP Limited, liability partnership firm, situated at Shikaria Compound, GS Road, Krishan Bosti, Kamrup Metropolitan, Gauhati, Assam. And for the same, the said company asked me to provide bank guarantee in order to purchase material from them. So to get the bank guarantee, I talked to two of my known person, namely one Sri Abhilash Kishore Kasap of house number, the same person, Lordship, the same petitioner, one Abhilash Kishore Kasap, house number 207, Hengrabari, near Hengrabari LP School, Gauhati, Assam, managing director of MS Zelise, and now he is also using the director of MS Zelise and Son. Two, Sri Rahul Gogoi of Gauhati, Assam, and they agreed to issue bank guarantee in my name in a condition that I have to pay bank charges of around rupees 15 lakh, and accordingly, I have paid them the rupees 2 lakh as advance money on 19 February 2022 via check bearing number so and so in favor to Zelisu and Son bearing account number so and so of Zoo Tin Ali branch on 10 March 2022. I have paid the rest of money, rupees 13 lakh, in cash to Sri Aheleteo, who is the partner of Sri Abhilash Kumar Kasap, after getting the soft copy of the bank guarantee. However, after getting the soft copy, I have forwarded it to the Bitumix India Limited liability partnership firm to verify it, but they personally replied that they have not issued any bank guarantee and the copy sent by me was a forged one. On my surprise, the petitioner here, Sri Abhilash Kishore Kasap, who is also the managing partner of MS Kampung and Kaimer Trading Co., have also given fake bank guarantee of rupees 1,79,666 to PWD NH Department Meghalaya for the project of Jawai Dauki bypass. While taking to the Bank of Maharashtra, they have confirmed me that they have not issued any bank guarantee to the PWD department. Hence, I request you to kindly take strict action against the said above mentioned person. The complaint was filed by one Rohit Kachari, son of Sri Arun Kachari, Madanting, Shillong, and the same criminal act, Lordship. Same criminal act was committed by the petitioner. And Lordship, I would like to place the CD, Lordship. This is the updated CD. And Lordship, the one which I have flagged, 17/7/2023, Lordship. If Lordship may kindly turn to the CD dated 17/7/2023.
17/7, yes.
Lordship, if I'm allowed to read, Lordship. This is dated 17/7/2023. Now I open the MCD at East PS for preliminary investigation, and progress of the case is shown in the previous MCD. Note 1. On contacting the proprietor of MS Kampung Kaimar Trading Co., now the owner, Mr. Gora Makik, was regarding the functionality of the said firm. Now, a letter of report received from Mr. Gora Makik, proprietor MS Kampung Kaimar Trading Co., citing that MS Kampung Kayam Trading Co. is a firm run under his proprietorships based at Arunachal Pradesh. However, due to the unauthorized, very important, due to unauthorized use of the firm, here the name has been by Mr. Abhilash Kishore Kasap, leading to forging of his signature to wrongfully gain contractual work, and due to which his aforesaid firm has been blacklisted. Since the said firm is been non-functional since past 2 years, enclosed report for the proprietor MS Kampung Trading Co. Exhibit 7. Lordship, may kindly come to the Exhibit 7, Lordship, which I have flagged. Exhibit 7.
Yes.
MS Kampung Kaimar Trading Co. Government registration APWRD Class 1A Contractor Building and Road, Head Office, Papu Nala Juli Road, near Diet Office, Nahalgon District, Papumpari, State, Arunachal Pradesh. 2. The officer in charge is Police Station, Dimapur, Nagaland. Subject, reply letter. Respected sir, the Kampung Kaimar Trading Co. is a firm run under my proprietorship, Mr. Garo Makik, based at Arunachal Pradesh. However, due to unauthorized use of the firm by Mr. Abhilash Kishore Kasap, leading to forging of my signature to wrongfully gain contractual work, and due to which my aforesaid firm has been blacklisted by the government. Therefore, it is certified that the Kampung Kaimar Trading Co. is being non-functional since past 2 years. Along with this, I am going under treatment at Delhi and I am not yet at station. Hence, I request you to kindly look upon the matter, please. This is a reply letter written by the proprietor to the officer in charge, East Police Station, Dimapur, Nagaland, Lordship. And Lordship may kindly turn to page Exhibit 8, Lordship. The next page, Exhibit 8. Lordship, this is to whom it may concern. This is with regard to the post-liver transplant of the proprietor.
The real proprietor.
The real proprietor, Lordship. Lordship, from the reply letter, Lordship, it was the petitioner Abhilash Kishore Kasap, who have unauthorized use of his frame by forging his signature, Lordship. And this was written by the proprietor, Lordship. Now, Lordship,
and what is this Exhibit 5?
Lordship may...
The apology letter.
Lordship, this is also... Lordship, if I'm allowed to read the Exhibit 5 also, Lordship. Lordship, this is dated 11/7/2022, Lordship. This is from the proprietor to the chief engineer, Lordship, if I'm allowed to read, Lordship. To the chief engineer, PWD NH Nagaland, NPWD Complex Kohima. Subject: apology letter and prayer appeal to replace performance bank guarantee. Respected sir, with all due honor and respect, we MS Kampung Kaimar Trading Company Registered Office near Dike Building, Julie Road, Nahal Lagoon, Arunachal Pradesh would like to state that we were allotted 2 of the works under your esteemed office under the banner of PWD NH Nagaland. Sir, we were entitled to work with MS Kampung Kaimar Trading Company, Nahar Lagoon, Arunachal Pradesh, who were allotted work under the Ministry Road Transport and Highway, PWD Nagaland. Name of the work: development of existing 2-lane pavement, including strengthening of NH 36 from 160,000 km to 166/880 km in Dimapur city portion in the state of Nagaland under PWD NH Nagaland. Therefore, sir, we have submitted our bank guarantee from the Bank of Maharashtra amounting to rupees 41,26,555, bearing number so and so for PWD NH Nagaland. Where after the submission of the bank guarantees, the esteemed department office has verified the BGs and has asked us to sign the contract agreement and go forward with the work. Till then, we were unaware that the BG was forged/fake, as the hard copy of the bank guarantee has come all the way from Badalpur, Mumbai to your esteemed office. Therefore, when the department after months pass away has gone for re-verification of the mentioned bank guarantee, it was declared forged fact by the Journal Office of the Bank of Maharashtra, Thane, Maharashtra, which was known to us by the show cause notice. Whereas, after the work was started and we have achieved physical progress of more than 5% in the project, suddenly department has issued show cause notice attaching Journal Office of the Bank of Maharashtra letter claiming the BGs to be fake and null. Hence, sir, When we were acknowledged about this matter, we have approached our district police and lodged FIR upon the person who has submitted B, BG claiming to be the third party collateral based bank guarantee as VMS Kampung Kaimar Trading Company had no intention to submit fact forged bank guarantee to your esteemed office or department. Hence, sir, we bow down with folded hands and apology to you and the esteemed office of yours and also to PWD NH Nagaland for misconducting this kind of issue where we got fraud by a person at today's date. Also, we got fraud after paying the agreed terms of money in regard to providing of performance bank guarantee. Also, we have visited his Mumbai office. We are not able to trace the person. Hereby, we are also attaching the FIR copy we file against the person. Thus, sir, we will be much obliged and grateful if our prayer appeal is accepted and we are allowed to submit new bank guarantee by your esteemed office in limited period of time, and we promise to never repeat this kind of activity again and getting fraud by a person. Also, we assure to put forward fixed deposit against bank guarantee to the department of the above mentioned bank guarantee amount. The above is for your information and records, please, assuring our continuous cooperation at all times will remain. Thank you, Lordship.
So this is by
My
the
this.
real
Oh
company.
no.
Lordship, this is
He is admitting that it was submitted by him, but he did not know it was fake, so he made a FIR to find out the person who has done it. He has not having found. Now requesting the authority that he'll be depositing the actual money or actual background along with the BG, etc. So he is requesting to pardon. So that's the case, my lord.
We are also attaching the FIR copy we filed against the person. So who is the person?
Yes.
Lordship, that copy is not there.
Who is
Lordship.
conducting this kind of issue where we got fraud by a person at today's date?
But Lordship, from the reply letter of the proprietor Lordship to the officer in charge of East Police Station Lordship, Exhibit 7 Lordship. From there, it clearly transpired that the petitioner, Abhilash Kishore Kasap Lordship, he has been forging the signature of the proprietor Lordship. And moreover, Lordship may kindly come to the, since the petitioner is since the petitioner is banking on the bond of undertaking agreement, Lordship, annexure O, Lordship.
Yes.
Here the petitioner is saying that on that very day itself, Lordship, when the police summoned, when the IO summoned the petitioner, Lordship, the petitioner was forcefully, he was threatened, Lordship. But Lordship, however, Lordship, basing on this bond agreement, Lordship, the bond agreement was signed between the complainant and the petitioner, Lordship. They amicably settle among themselves, Lordship.
So now are you trying to say that this letter dated 25/11/2021, annexure D2, by which the bank guarantee was deposited, this signature has also been forged by the petitioner?
Lordship, from the reply letter, Lordship, it's clearly transpired, Lordship, to the officer in charge of the East Police Station, Lordship. And this is a part of record, Lordship, which has been Exhibit 7, dated 17/7/2023, Lordship. So, Lordship, there is a prima facie against the accused, against the petitioner, Lordship. Lordship, by signing a bond of undertaking agreement between the petitioner and the complainant, Lordship. On the strength of this, Lordship, the anticipatory bail 2/2023, Lordship. This Honorable Court, by an order dated 10/4/2023, has made it absolute, Lordship. By reflect, Lordship, if Lordship may kindly come to the relevant portion, Lordship, page 114, Lordship.
Yes, that was read out.
Lordship, that was read out, Lordship. So, Lordship, on the strength of this bond of agreement, that was bond of undertaking agreement, that was signed between the parties, Lordship. This anticipatory bail application was made absolute, Lordship. So now the petitioner cannot turn and say that it was forcibly done, Lordship. So since
In the same page, my lord, it is clearly mentioned, however, the said submission relied on the case that is disputed by the learned senior counsel for the applicant. Page 114, first paragraph, last line.
And moreover, Lordship, page 123, Lordship, the notice of the police which was sent it to the petitioner, Lordship. Since basing on the bond of agreement that was signed between the complainant and the petitioner, Lordship, since the petitioner did not abide to the bond of agreement, Lordship, Lordship, this is just notice under section 41A was sent it to the petitioner saying that the remaining amount that was to be paid was not paid till date.
No, but can the police recover such an amount is the question. Because that would be only recoverable through a suit.
Lordship, in fact.
Police cannot recover such an amount which is due by way of the agreement. That cannot be. If you're submitting on the question of the BG, the bank guarantee, that is a different issue. That may attract criminal case, as it is. You are saying that it was forged.
Lordship, it was forged.
But as far as the amount which is due arising out of the agreement,
Lordship,
that cannot be the subject matter of a criminal proceeding.
Yes, Lordship. Lordship, Lordship, the FIR has been lodged in the East Police Station, and the same offence has been committed by the petitioner in the state of Meghalaya, Lordship, where one, namely Rohit Kachari.
That is a different thing.
Lordship.
Then another similar FIR lodged by the chief engineer is also there at the North Police Station, South Police Station, Kohima.
Lordship. So the instant matter, Lordship. Instant matter is a criminal in nature, Lordship. It's not a civil dispute.
No, okay. Another aspect is even assuming but not admitting that it is criminal in nature, can a second FIR lie in respect of the same offence?
No.
It has to be either clubbed together and taken up in one police station, because it cannot go on in different police stations at the same time.
No.
That aspect also there. Okay, then.
Therefore, Lordship, the petitioner is saying the petitioner is alleging saying that the prayer before the honourable court is this matter is civil in nature, Lordship. However, this matter is criminal in nature. There is a criminal ingredient of 406, 420, 465, 467, 468, and 471.
Okay.
Yes.
Here for complainant.
Number 2.
Complainant.
Worship, the second agreement, which was executed on 23/3/2023, which Worship rightly pointed out, regarding the agreement for payment of some certain amount by the complainant, by the accused to the petitioner. Worship, this is a subsequent event which has been entered between the parties after the after the complaint was filed by the complainant on 12/9/2022.
Yes.
Sure. In the complaint 12/9/2022, here the complainant is alleging against the present petitioner for the forgery which is committed. Worship, so this second agreement in the which is the condition which has been raised in the complaint, 1292, these are separate, Worship. Worship, now the complaint is only against the allegation is only against the complaint which is made in the complaint in 12/9/22.
12/9/22.
Yes, Worship. Worship, since the learned public prosecutor has demonstrated the records, Worship, I'm not repeating to all that. Worship, but if we see from the case diary, if we see the report issued by the proprietor of this Kampung Maya,
That letter dated 17/7/23.
Worship, if we read this letter, this 17/7/2023, should me read just a repetition.
Yes,
The Kamyar Trading Company is firm run under the proprietorship Mr. Kuram Malik. So from here it clearly demonstrates the proprietor is Kuram Malik. Based at Arunachal Pradesh. However, due to unauthorized use of the firm by Mr. Abhilash Kishore Kashyap, leading to forging of my signature to wrongfully forging his signature to wrongfully can contractual work. This is the ground, and it is related with the present case also, and due to which my opposite firm has been blacklisted by the government. Therefore, it is certified that Kamyar Trading Company is being non-functional since past 2 years. Worship, this very word since past 2 years is very important to determine this case. Worship, this letter was issued on 17/7/2023. So it's referring to it's not functional since past 2 years due to his medical treatment, and which my public prosecutor has already shown the record of his treatment also. 17/7/2023. If we see this 17/7, then if we release back to 2 years, it will be 17/7/2021.
2021.
So his firm is not functional since 2021. Worship, may kindly come to a writ petition. The fact is not disputed. The contract was awarded to this Kamyar Trading Company, Worship. And along with that letter of acceptance, the present petitioner, he approached the complainant and he executed the agreement for executing the work. That fact is not disputed in this case. And after the present petitioner, he approached the complainant, the executed an agreement, that is, the agreement was executed on 22/12/2021. Worship, the agreement, the type copy of the agreement is annexed at page number 65.
Where is that?
65. 22/12/2021. They have executed this agreement for executing the present contract work. So if the original provider says that since past 2 years his firm is not functional, the allegation which he has made in the letter, the present petitioner has been forging his signature. It also relates here, Worship. And it should become the page 69, the condition number 3. The present petitioner is a principal contractor in this term of contract, Worship. The principal contractor, got it? Page number 69, clause 3.
Yes.
The principal contractor shall deposit performance security of rupees so and so, as demanded by the owner to the principal contractor within the stipulated time mentioned in so and so. So as per your terms of agreement also, the present petitioner is supposed to deposit the bank performance calendar. And the present petitioner, they have made a specific statement in their petition also, he has no knowledge or neither he has submitted the bank guarantee. That is your condition. And because of submission of forged bank guarantee, the contract has been terminated. And due to the termination of the contract, now the present complaint is financially suffered. And for that reason, he has submitted this complaint, requesting the concerned police station to investigate into the case. By the letter of 17-7 issued by the proprietor of this Kambom trading company, it clearly demonstrates that when his firm is not functioning, as on 17-7-2021 for the last 2 years. In that case, it clearly demonstrates that the present petitioner, by forging the signature of that very company, he came and executed this agreement with the complainant, with me, and thereafter I was put to great financial loss. So, Worship, the criminal engine is highly demonstrated. Worship, to the FIR does not call for interference and let the police complete the investigation. Worship. And regarding the second FIR, which they have annexed in the by filing an additional affidavit.
The one which is lodged in Kohima.
Yes. Your Lordship, the complaint which I filed against the present petitioner is against his act of forgery. I'm not here. The main issue is I'm stressing on the agreement which we have executed between us, and by violating this agreement, Lordship, now the state government has already terminated the contract, and now I'm suffering the financial losses. That is a crime. And here specifically I've submitted this FIR against the present petitioner. Lordship, if you see the contents of the second FIR.
You're also alleging the forgery of the bank guarantee also.
That also I'm also, since it is a causes it arose of the submission of the forged bank guarantee.
Yes.
But if you see the contents of the second FIR, which was filed by the chief engineer BWB, to the officer in charge South Police Station. Here, the complaint is against Amy's Kampung Gambir Trading Company. That means against that firm, not against the petitioner, but it is against the firm Kampung Gambir Trading Company. Now the action, offense may be,
it will be the same thing.
Because against a different person,
it will amount to complaint against the petitioner only.
Due to the act committed by the present petitioner, this also arose, Lordship. But my FIR is against the present petitioner. In the second FIR, this is against the proprietor of Kampung Gambir Trading Company. So this FIR cannot be termed as a second FIR against the present petitioner. In the contents of the FIR.
But ultimately, the investigation in this Kohima case also, it will reveal, it will come back.
Yes, it will correlate with the Timabo case. Exactly. But here in the second FIR, here the action of the present petitioner is also not specifically mentioned. They are only asking for an investigation. But this FIR is filed against, since it's filed against the Gambir Trading Company, so this FIR cannot be termed as a second FIR against the petitioner. Only after the completion of the FIR, that can be come to a conclusion.
Because see, in your complaint letter,
yes,
also you have said, you have stated the same thing.
Yes, due to the submission of the forged,
the performance bank security deposit by Mr. Such and Such was fake and forged.
Yes,
all those you have stated.
Worship, now the entire action, the entire course of action, it arose due to after the signing of this contract agreement. And this agreement was signed by the petitioner, present petitioner approached the complainant and signed this agreement by forging the signature of the original firm. So the criminal act is clear. So the detailed inquiry is required in this case. So let the investigating agency complete the investigation. In this, since the present petition, this has been filed under Section 482, bring for causing of the complaint and the subsequent registration of the FIR by the police. In this case, the law is settled by the Honorable Apex Court. So I'm relying only on one judgment in this case.
Yes.
Lordship, I'm relying on 2021, volume 19, ACC. Page 401, Lordship. I'll take your Lordship to paragraph 33.
Yes. You have supplied the copy,
Yes, Lordship, I will submit a list of books.
2021, 19 ACC.
Do you need 2119 ACC 401, Lordship? Lordship, I'm relying on para 33. Lordship, in this para
Niharika infrastructure.
nearly Lordship. Infrastructure, Lordship.
32.
33, Lordship. Lordship, here in this case, the base course already laid down the guidelines.
Yes.
Lordship, since I will not pertain Lordship to all the paragraphs, Lordship, I'll come to paragraph 33.15. 33.15. This is a guideline laid down by the base course. When a prayer for quashing the e-fire is made by the alleged accused, all the court, when it exercises the power under Section 482 CRPC, only has to consider, this is very important, only has to consider whether the allegation in the e-fire discloses commission of a cognizable offense or not. The court is not, this is important, the court is not required to consider on merit whether or not the merit of the allegation made out a cognizable offense, and the court has to permit the investigating agency, police, to investigation the allegation in the FIR. This is very important. Bishop, as per the subsequent investigation carried out by the investigating agency, Bishop, now all the acts committed by the petitioner is coming to it. So let the process of investigation come to an end. That is all my submission.
Yes, Mrs. Sakya, anything?
My lord, boiling down to the point, the respondent number 2, my lord, the learned counsel has said that the FIR is concerning only the agreement. If I have understood correctly, my lord, his FIR which has been lost is only confining to the agreement, though the recitation has been given for the submission of the fake my lord, BG. So if it is concerning the my lord, agreement, it's a purely my lord, a civil dispute. It can be executed by execution of the my lord, agreement, for enforcement of the agreement, specific performance of the agreement, for which I have already instituted a suit. So criminal proceeding cannot stand at all. And secondly, the letter read out by the public prosecutor, which was written by the proprietor of the Kampung Kamyak, clearly says, my lord, that he has submitted the BZ without knowing that it is a fake. And when later realized from the Maharashtra also that it is a fake, he has submitted an FIR. He has not said it has been done by the present petitioner. Now, second aspect of the matter, what he is saying, that the farm was inactive or farm was devoured for last 2 years. How he has entered into a contract? Why he has again prayed before the authority that to give him some opportunity to submit the BZ afresh and continue with the work. These are the one co-accused alleging against the co-accused. Law is well settled, my lord. Statement of co-accused cannot be taken into consideration for the purpose of deciding the guilt of the another accused. Now, pure and simple, my lord, from the reading of both the FIR, it clearly appears it is concerning the same submission of the fake BG. And the FIR lodged by the chief engineer is prior in time. So therefore, second FIR at the Dimapur PS cannot sustain. And Lordship has seen, my lord, that the complaint was lodged way back in September 2022, and this has been registered only on perhaps 2/5/2023. No, 8/8/2023. Well, much after the filing of the present petition.
FIR was lodged on 28/8/23.
28/8/23 in the Dimapur PS.
Yes, Dimapur.
Whereas complaint was lodged on 12/9/2022. So therefore, I have submitted the 1974. What is the role of the IO? It is apparently a subsequent FIR cannot be could not have been registered by them, and the record perhaps has not read out anything. The police has not gone. The basic owner of the property was who has been cheated is the
No,
NH department.
yes, Mr.
But
Saki, what I gather from this letter of Exhibit 7 in the case diary, the owner means to say that even the work which is allotted in Nagaland, this instant work order, was allotted without his knowledge, isn't it? That's what he's trying to say, isn't it?
Lordship. And in fact, Lordship,
And this apology letter is also written by the petitioner,
no, by the proprietor, Lordship.
by the proprietor,
Lordship.
the real proprietor.
The real proprietor, Lordship. Lordship, may kindly come to Exhibit 7, Lordship. The signature of the proprietor. Down below, right, extreme right. Lordship.
No. So Exhibit 7, okay, fine. That is written by the real proprietor. I'm talking about this 11/7/2022 letter written to the chief engineer. Apology letter and prayer appeal to replace the performance bank guarantee. This one.
I hope PP would not say it is also forced.
Lordship, authorized signature. Is simply state that it's an authorized.
No, that's why.
Lordship.
The learned senior counsel is saying this is written by the original owner, the original proprietor.
No, not by the original proprietor.
So this is
Lordship,
also written by the petitioner.
Lordship, signature is appear to be different, Lordship. If
it's written in the year 2022, Lordship, it will be the authorized signatory, he's the petitioner himself.
present petitioner.
Signature is different. of course.
Signature is different. The proprietor's signature is different, and the
And this
letter,
signature in the letter dated
Lordship.
11/7/22 is different.
The authorized signatory may be on behalf of the proprietor, someone else can sign, so therefore that happens. But question remains, the letter by which he has submitted the bank guarantee is stated to be forged. Number one. Secondly, mayor saying that my farm was inactive, so for last 2 years it was inactive. The present petitioner has utilized it. It's a contract of crores, the authority would not, accept a tender without having all income tax receipts, etc., but all these things are necessary. Capability, the work, executed if the tender conditions are gone into, Just to, save his skin, he is submitting a letter, but police has not the way made an endeavor to catch hold of me, have not done anything, only sought certain letters from him, and he is scot-free.
Lordship, from the Exhibit 7, Lordship, it clearly appears that it's been non-functional since the past 2 years.
Yes.
Non-functional, and accordingly,
Acha, where is that letter depositing the BG? Page.
Page, page 60,
D1, na? Page
60. This is signed by the proprietor himself.
But see, Mr. Zimomi, the signature at D2, page 60, and the signature at Exhibit 7,
Lordship, is different.
it's isn't it tallying?
Page 17,
The letter dated 17/7/23 and
different.
the deposit of the BG. See?
Signature is different.
No, it looks the same.
Lordship, in fact, it does not tally also. Not telling.
Okay. Anyway, yes.
Lordship, when the allegation in the letter dated 17/17/23, it's alleging about the forging of my signature.
Working of-
Everything was
So it does not tally.
everything is possible. Forging of my signature. That is alleged.
The oral statement of the co-accused, my lord, to that extent, my lord, various, my lord, pronouncement of the Supreme Court is there. Of course, it was not brought to my notice earlier, this allegation. Now, my lord, I can just refer to AIR Online 2025, Supreme Court 511. My colleague will supply a copy, my lord. After I'll just read out, my lord,
Yes.
concerned paragraph.
Hmm.
AIR Online 2025, Supreme Court 511. Paragraph 50.
You just
Even where the
printouts later. Yes. Yes. You read, it's okay. I'll take the printouts later.
yes, ma'am. Even where the police statement of an accused person under section 161 of the CRPC is neither an admission nor a confession. That is, it is exculpatory in nature and not inculpatory. Such statement can be looked into by the courts only for the limited purpose of culling out the stances of accused person qua the allegations. An exculpatory police statement of an accused person under section 161 of the CRPC, which at the same time implicate another co-accused, cannot be relied upon merely because such statement is not hid by safeguards and rigors that apply in respect of inculpatory statement in the form of an admission or confession under the Evidence Act. The fundamental cannot of criminal jurisdiction is that a statement of one accused person cannot be used against another co-accused person. The limited exception to this aforesaid general principle are inculpatory confession, where the accused person in his confession statement not only admit his own guilt but also implicate another co-accused. That is 2025. But these, my lord, are perhaps in my submission would not come into, my lord, the discussion. Firstly, because it has to be seen, my lord, whether on the same set of facts two FIR has been registered, and the FIR on the first point of time would prevail. The remaining whatever will there will be a subsequent statement which can be taken into consideration along with the first FIR. So therefore, this FIR has to be quashed. Whatever materials they have collected, it can be given to the Kohima PS for further investigation. That's number one. Secondly, although the first FIR, my lord, the criminality can be, my lord, ascertainable only from the statement that the BG are fake, and that was submitted by the petitioner. Apparently, on the face of the, my lord, D2, which has not been disputed. I have already said, my lord, the statement, various statement I have, my lord, read out, which are neither, my lord, denied by the respondent number 2, nor, my lord, the PP by filing any additional. And the so therefore, my lord, these documents become innocuous document which can be relied on for the purpose of, my lord, present case. Now these whether signatures are to be, my lord, genuine or not, these will be, my lord, decided at a later stage when forensic all these things will come. Merely the one accused person saying he has forged my signature, it is not me. By that, my lord, one cannot be, my lord, implicate the other accused. So only two legal question arises. That second FIR cannot survive on the face of the first FIR. Second is that it is purely a civil in nature. The agreement, your lordship has seen the third. If I pay the amount 30 lakhs, the case will be closed. That was the third. If I lordship take to the again, my lord, the which my lord, the time
No, that
constraint, I'll not
is one of
take.
the aspects. Yeah, that is just one of the aspects of the case.
Yes,
One of the aspects.
one of the aspects. So if I pay the amount, there will be no case. Otherwise, case is live. That was the police says, and they said that is an agreement executed voluntarily without any coercion, etc., etc.
Maybe,
Now
maybe.
that
But as far as this court is concerned, the court is only concerned with the FIR, whether any offense is made out or not.
exactly,
That's all. That's all.
exactly.
And,
That's all.
the court has to see that only, what, not the subsequent developments and all those.
Yes, yes. And also see, my lord, that whether it is a civil dispute. If it is, my lord, predominantly a civil dispute, it will not be, my lord, encouraged to go for a criminal law for execution of certain, my lord, civil dispute. So
Okay.
these are my VI Jose. I have also referred some other judgment, but then old judgments are VI Jose and others. AR 2009 SC, my lord. Supplement 59. My lord. This I have did not, my lord,
That is there in
read
the
out.
list. That it is there
Yes,
in the list. VY Joe.
yes, my lord. Yes, VI Jose lordship perhaps is there, lordship. I did not refer because repetition would not, but these are the many
These are
cases
all
which
there
would
in the
say
list, so I will look into it.
lordship.
The printouts, okay, later. You just take this and then only the relevant paragraphs, not everything. And then if there are any additional book list which you have given today, that also, the relevant paragraph only, you just give it to him, okay?
Yes, 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 yes.
Right, Learned Senior Counsel, Mr. P.G. Saikia, assisted by Ms. Tai Kruller for the petitioners, also heard Mr. V. Zimomi, Learned PP, and Mr. Lim Mawapang for the respondent number 2. Yes, 2 and 3? 2. Yes. Matters disposed of. The chamber.
Apang knows true fact, man.
Yes.
Counsel Apang knows the true fact, man. In a lighter way, my lord, in a lighter way. Bless.